and everything. I've really enjoyed your insights. And today also the topic being something that you've also come out with, I think, which is really important, the cross-border enforceability of settlement agreements. But before you go to you, I started this new thing, which I don't know whether you've seen in my other shows, that you are going to tell me or tell us about the conference. So Dimitri, what do you know about the conference? You have to tell us.
Well, I know that many people from various jurisdictions share their views on various acute issues. Well, each one on some area of his or her expertise, always related to amicable dispute resolution. And that's just, I would say, not not something completely new what you are organizing. I mean that that's a step, kind of one of the numerous events related to mediation and dispute resolution, which you, Vikram, organize. That's briefly what I would say about the conference.
Perfect. So a little bit of, I'll just point out that it started on 18th May, it'll go up till 30th June. The schedule is on social media. If anyone wants to participate, I've already written there, please share the post and I'll get back to you. Just use the hashtag Mediator Vikram, and all the recordings are available on YouTube. So please just search for Mediator Vikram, you'll find the channel. So that's the thing that I needed to do. Now, Dimitri, the show is yours. Please take it forward. You have to start with yourself and then move on.
Okay, so my name is Dmitry Davidenko. I am a lawyer qualified in Russia. I speak, apart from English and Russian, I also speak French, Italian, and some German. I specialize in international dispute resolution. I mean, mostly commercial, private disputes. I teach private international law and transnational civil procedure at several universities, including those in Russia and Uzbekistan. So I take part from time to time as a mediator in some cases, and more often as an arbitrator in international cases and other cases under the rules, for example, of International Chamber of Commerce and various other institutions. I'm on the list of Hong Kong International Center of International Arbitration, in Kazakhstan and some other countries. Well, the topic of my speech today is cross-border enforcement of settlement agreements. I believe that it is always important to find ways to settle disputes amicably, and it is especially true nowadays where there are numerous obstacles to proper fulfillment, performance of contracts, especially international contracts, and numerous obstacles. One come and do not go, another obstacles arrive, and who knows when they will go, like, well, pandemic, which caused numerous situations where a party was not able to perform a contract. Then now numerous, at least in Russian context, different, and some other countries, not only Russia, many situations where there are restrictions on numerous transactions, and it becomes just impossible or impracticable or very hard to perform a contract, or even if not, then a dispute arises, and it becomes especially difficult to recognize and enforce a judgment if you even decide this dispute, solve it through a court procedure. It may be sometimes also difficult to arbitrate a dispute. It may take much time and efforts, and the result sometimes, unfortunately, may be not enforceable for various reasons. So the ideal solution is for parties to be wise, to cooperate in the spirit of good faith, do some, as much as possible to keep the contract, or if it's impossible to, terminate relations in a way that no one feels offended. And one of the perhaps most appropriate instruments to that is the settlement agreement. It happens that although many people know well what it is, or at least there is always an idea about that, still in many legal systems there are various understandings of settlement agreements. Some of them are considered, it is included in substantive law of many states of continental Europe, like in France, contrat de transaction in Italy, transazione in Greece. There is a special chapter in the civil code about settlement agreement. In other countries, there is no express regulation of this contract, so it's just exists in practice. It is, of course, concluded, used, and unfortunately, there are situations, of course, when it is not fulfilled, or at least there is a perceived risk for parties how to ensure its performance. This becomes especially relevant in the international context, when there are parties from different jurisdictions, or which enterprises, which businesses are in different states, assets are in different states, and of course there is a legitimate interest of the parties to, when they settle, to make sure that the settlement is final and it will be complied with, and if not, there are some possibilities to enforce it. In international context, it's perhaps even more difficult. Of course, many people know, there is now the Singapore Convention, although it's not about any settlement agreement, it's about enforceability of settlement agreements, cross-border enforceability of settlement agreements reached as a result of mediation, which is, of course, very important, because if a settlement agreement is reached as a result of mediation, which is properly conducted, then normally it is something which should correspond the interests of the parties. So it's good and normal to ensure its expedient performance. But as again many people know, Singapore Convention needs time, maybe much time, who knows, to become effective in many states. Now it is in force only for about, if I'm not mistaken, about 8 states or so, not probably not more.
10 have ratified it.
Oh, 10, yeah, that's 10. Interesting. It's in many several continents. In Eastern Europe, for example, and let's say my region, it's Belarus and Kazakhstan. Kazakhstan, it's not yet in force. It should become operative in November this year. Well, the problem is, so as with many conventions, that it needs time. Another problem is just an international consensus. The convention is a fruit of international consensus. It was hard work. I know people who personally took part in it, and I heard their stories, how difficult it was to reach a mutual solution so that many jurisdictions adhere to it. As any consensus, it's not about some quite expedient enforceability. It's just some uniform rules, about uniform rules that a party asks the competent court to enforce the agreement, but the other party has quite plenty of opportunities to oppose enforcement. May say that the content is contrary to applicable law, that it is not operative, well, void for some ground, and there are several other reasons. So it's quite a court procedure, not I wouldn't say it's very expedient procedure. That may depend, of course, on the jurisdiction, but if it's something even more, maybe even more protracted than the New York Convention procedure. So we cannot. I think that lawyers should think about something, some other ways to ensure enforceability of settlement agreements cross-border, apart from Singapore Convention. And what I see today, I would summarize what are possible approaches now. The most maybe the most common approach is to enforce the settlement agreement as a common contract, just a contract. So contract, then it will be a judicial procedure. If there is an arbitration clause in the settlement agreement, it may become more expedient. I think it's always a good option to consider to include into the settlement agreement a mediation clause, and then also an arbitration clause, so that the time will increase the chance of enforceability or compliance with it, and then if necessary, the enforceability of the arbitration clause. The way how it will be enforced would perhaps depend on the particular legal system. And briefly, in let's say civil law countries, perhaps more possible remedy, legal remedy would be specific performance of the agreement if there are some actions to be taken under this agreement. In common law countries, damages are perhaps the primary remedy, to the best of my knowledge. In this regard, it may be important to take into consideration while recording or agreeing upon formalizing, drafting the text of a settlement agreement, to think about applicable law clause, to submit submit it to some applicable law, and what will depend on that. In my understanding, the way how the mutual rights and duties of the parties will be interpreted would depend on the applicable law, including the case law. The remedies in case of non-performance of settlement agreement would also be, they would depend on the agreement itself, but also on the applicable law. Just as an example, again, to the best of my knowledge, for example, in Australia, normal remedy is under Australian law. Normal remedy would be damages, and specific performance would be only in relation to some unique objects, some unique for example, unique real estate objects, which are not, or something which cannot be acquired in the market. Under Swiss law, again, the damages, on the contrary, would be applicable, maybe awarded only in case the specific performance is impossible. Again, there are different legal traditions as regards the force majeure. Like in common law, there is no default rule in many countries of common law, no default rule on force majeure. So it's what you include in the settlement agreement would be your force majeure event. But in countries of civil law, normally there are default rules in the legislation about force majeure. And many other examples, like good faith principle, which may be more relevant in civil law, and other legal doctrines. Another, in this regard, there are some important things to consider when drafting the settlement agreement, like to include into it a duty to sign necessary documents for performance of the agreement, and perhaps using escrow mechanism of dealing with money, because one of the parties may be reluctant to transfer the money to another before the other party performs their part of obligation. So the money may be put on a escrow account of a third party, and that might solve this situation. Another just an interesting example how it may be without contracts. What is under Russian law, for example, if a settlement agreement, a mediated settlement agreement, is notarized in Russia, then it becomes directly enforceable again in Russia. So it may be helpful for international disputes as well. Just the parties ask the notary public to certify the agreement, then it becomes directly enforceable to the court relief services and to the banks, and so on. But it's not so easy about the recognition of notaries, of notarized agreements outside the country. I think that's the problem in many jurisdictions, that notarized agreements may be recognized and enforced in the country of their origin, but not necessarily in another country. So it may be helpful for one party to the agreement, but not to the other. That depends on the existence of an international treaty between the relevant countries and other relevant mechanisms. Some groups of states, like the European Union, have their own regime of international possibility of, for example, authentic instruments, which are in fact notarized agreements is an authentic instrument, as I understand. So if the authentic instrument is such as a notarized settlement is entered into in one EU member state, it would be enforceable in any other EU member state under the Brussels regulation. And there are also there is a regime under the Mediation Directive in the EU, which provides that each member state of the European Union must ensure that the settlement agreement reached in mediation is enforceable in other EU member states unless its content is contrary to the law of this state, or unless this law considers this agreement unenforceable. So this is a simplified regime which exists in many or in some regions. Of course, I would be happy to learn more about such regional mechanisms from lawyers from other jurisdictions. That's a part of my one of the purposes of my presentation is to also to put this problem and ideally to share views with other colleagues, maybe to receive some feedback on that, how it is in other jurisdictions, how you enforce the settlement agreements, which mechanisms exist. I looked into the European legislation in that regard, and I see that, for example, in Slovakia, if mediation is, the settlement agreement is recorded as is notarized or recorded by the court or by as an arbitration award, then it is enforceable directly. Again, notarized agreement is directly enforceable, to my knowledge, in Spain, Germany, and Austria. And in England and Wales, there are three ways to enforce, three regimes on enforceability of settlement agreements. As a common contract, first option. Second, as a settlement deed, which is an expedited enforcement. And perhaps the most expedited enforcement is by Tomlin order. That's about existing mechanisms. So it seems to me that from the purely practical viewpoint, if a party needs to ensure the direct enforceability of the settlement agreement in a certain jurisdiction, it should explore the option to notarize this agreement in this jurisdiction. Maybe very simple, but I think that working solution. So the national notary would just record it. It may be more expedient than applying to court, but in some jurisdictions you may just apply to a court without initiating a full-scale court procedure. Just apply to state court, and it would record it as a directly enforceable agreement by its order. That's about practical ways to enforce the agreement. Of course, there are such ways as another situation is when the settlement agreement is reached within civil litigation, and the court records it as a court judgment, like it is in Russia. Then it becomes enforceable as a court judgment. But again, there is no universal enforceability of court judgments. Unfortunately, it is limited again to several states. It depends on the existence of international treaty or the reciprocity, international committee. There is already, as many people know, the convention, the Hague Convention on recognition and enforcement of foreign judgments in civil and commercial matters of 2019. But again, it needs time to become effective. There are very, very few, only 6 state parties, and they all just signed it. No, not yet in force. Also, unfortunately, this convention does not provide for enforceability of authentic instruments. I think it's a pity. That would be interesting, good, and helpful if the same convention was not only about court judgments and settlement agreements, but about authentic instruments. But for some reason, this is not included in the convention. And finally, that's the final, probably not, well, the final point of way to enforce the settlement agreement is by means of arbitration, enforced internationally. The most obvious approach is to initiate arbitration, then the parties reach a settlement agreement, and it's recorded. They ask the arbitral tribunal to record it as an arbitral award on agreed terms. Then it becomes enforceable as any arbitral award under the New York Convention 1958. This option definitely looks well. Obviously, the arbitrators, well, there is it's not obvious, but there is general understanding that arbitrators should render the consent award if the parties request so, unless they find that there is some violation of law, the content of the agreement is against public policy, let's say, against applicable law. If they find some money laundering, so some exceptional situation, but normally it would be a consent award enforceable as under the New York Convention. But the problem is that arbitration is sometimes not really a cheap procedure. You must pay the arbitration fee just for recording the agreement into the award. Some arbitral institutions, including in Russia, already provide a simplified procedure, arbitration procedure, exactly for recording a settlement with a reduced fee, which I think is very good, that arbitral institutions make this step to accommodate the needs of the parties who do not need a full-scale arbitration, but just want to ask the tribunal to merely to render a consent award based on the agreement. There are some such options in Stockholm Arbitration Institute and the Stockholm Chamber of Commerce, in the Russian Arbitration Center, under the Russian Institute of Modern Arbitration, and several other institutions. But unfortunately, there is no consensus, no guarantee internationally that this award would be recognized and enforced in other countries. The reason for that is that, strictly saying, to start an arbitration, you need an unresolved dispute. So from the rather formal point of view, if you already, the parties reach a settlement agreement, there is no more dispute. No dispute, why you go to arbitration. So you're just that would not be an arbitral award. That's a possible approach, which I already faced. I mean that I have found at least one case in 2019 in the United States Court of Appeal of the Ninth Circuit, in which case the court refused to recognize and enforce an arbitral award exactly on the ground that it was exactly on this particular ground, that the parties first settled their dispute by agreement and only then asked the arbitrator to record it as an arbitral award. And it was made in Philippines. The US judge found that it should not be enforceable under the New York Convention because it's not a there was no arbitration as such. So this problem exists. What I would suggest to solve this problem, because the spirit of favorizing the settlement of the parties calls for enforceability of such arbitral awards. That's a legitimate interest of the parties to settle their dispute and to make it enforceable through arbitral awards. But what can be done in that regard? What the parties themselves can do is to include in the mediated settlement or into a settlement agreement a condition precedent that the agreement will acquire legal force only if the arbitral tribunal approves it. So that the agreement is not yet in force unless and until the arbitral tribunal approves it. This means that the dispute is not yet resolved. It exists. The agreement is not yet operative. And so there is a ground to apply to arbitration. So just an option to consider if possible under the particular applicable law. I think that, for example, under Russian law, this is possible. What can be done on the global level? Because this approach is maybe not satisfactory to some parties. That the agreement is not yet operative until approved by the arbitral tribunal. Some parties may be unhappy with that. So a solution to what can be amended on the global level, and perhaps the proper authority here is the United Nations Commission on International Trade Law, UNCITRAL. My proposal is to develop a recommendation on the application of the New York Convention in that regard, to recommend to the contracting parties to apply the convention to those arbitral awards on agreed terms which were rendered as a result of the parties' recourse to arbitration solely for making such an award under the conditions when the dispute has already been settled by them in an amicable agreement, in particular resulting from mediation. So briefly, to apply the convention to the arbitral awards made by an arbitrator who was asked only to record the settlement without any procedure. And the second proposal from me in that regard on the global level is to amend the Article 30 settlement of the UNCITRAL model law on international commercial arbitration, first paragraph of Article 30, to include it, to supplement it with a sub-paragraph that, for example, my proposed wording is that an arbitral award on agreed terms may be rendered by the arbitral tribunal also if the parties, without resorting to arbitration, settled the dispute by settlement agreement during the mediation procedure and then applied to arbitration solely for the purpose of making such an award by the arbitral tribunal. To expressly provide for such a situation in the model law. I think that that could be helpful to ensure proper enforceability or easier enforceability of cross-border settlements. Another approach would be, or amendment would be, to include the provision on authentic instruments into the Hague Convention on recognition of foreign judgments, and to also for the various jurisdictions to provide for enforceability of notarized settlements in their international treaties and national legislation. On that, I would conclude my presentation.
Thank you, Dmitry. That was really nice. Of course, there are certain issues that we need to discuss because of the fact, the last thing that you said, that they should in some way amend the model law Article 30, or the kind of the states can make some changes there. Then you're basically saying that instead, why can't we just say that they ratify the Singapore Convention? Why do, that's all that's required, rather than going through this route and saying that to come into the New York Convention, you need to do this. That's all that's required. It's you have a convention lying there, sign it and ratify it. Because I'm still saying that there will still, I mean, it can be still be interpreted that even if you can amend it, but that won't be in the spirit of the New York Convention. So I still feel that it's not something that should be attempted. And what you pointed out, actually, a lot of people don't know this aspect of, okay, we'll get into a settlement agreement and we'll go to an arbitrator and we'll get a consent award. That definitely can be challenged. So I think that way, I mean, this actually, a lot of people don't know this, because I hear people talk about it. And I've heard someone handles one CEO of a arbitration center somewhere. He was asked this question and he actually did not answer it properly. So I'm just saying what message you send out, because look, only if it's challenged, then there's an issue. And people don't even know this and continues. But one matter also goes like that. Imagine the costs involved in that whole thing. But why can't we just let them go for arbitration? If they want to use the New York Convention, let them just go for arbitration and then say, let it be settled outside and then come back to the arbitrator. So they should first maybe initiate the arbitration and then they can go there. Do you see any issue in that?
Do you mean, if I did understand you correctly, that what you're saying is that first to start arbitration, yes, then ask the arbitrator to render the consent award?
No, I'm saying you start the arbitration and then you go in for whatever, it could be mediation or whatever other name you want to give it, to settle the matter. Yeah. Come back to the arbitrator and the arbitrator passes the consent award. So
yeah, sure, that's an option, and that's what should be, of course, considered. Yeah, but for some parties it may be just they don't like the need to pay the whole arbitration fee.
No, yeah, what I'm saying, in a situation where actually your plan is to try and settle it amicably, in those kind of situations, like you said, look, arbitration centers and arbitrators are always willing to be flexible. So the parties say, look, basically we're trying to settle the matter, but we want to initiate the arbitration. And if they don't settle it, they don't have to come back for the arbitration. That's their flexibility. They don't do it. Finished. So it's just that initial thing. I'm just trying to say that people trying to use the New York Convention, there are enough ways they can come to Dimitri and say, look, Dimitri, today we are appointing you arbitrator, but we don't really want arbitration. We want to go settle it. But on paper, you show us arbitration. That's the way. So people are trying to misuse the New York Convention today. So misuse it in a proper way. Why misuse it in a manner which can be challenged? But Dimitri, first thing is that in terms of grounds for refusal of enforcement in various, whatever, first of all, Singapore Convention, New York Convention, and all those issues that you have seen, the practical problems you've seen in various countries, something there you want to talk about?
Just could you repeat, please?
The grounds for refusal of enforcement in various countries, what are the practical issues that you have seen that have come up in that?
One is what I said, that the unresolved dispute, non-existence of unresolved dispute. If there is an arbitral award made after the dispute was settled. Another, perhaps that's not something I would be in position to comment now, because it needs more research, what other problems exist. But as regards enforcement as a contract, then usually that depends on the particular situation, of course, whether the particular contract was made, let's say, in good faith, then whether some internal procedures which a party may refer to, that, for example, if two companies enter into a settlement agreement, one of the businesses promises to pay some sum of money or to another, or to transfer some assets, some property, and then that party starts to refer to non-compliance with some internal procedure, that, for example, the chief executive officer signed this agreement, but the shareholders did not approve it. And in some situations that may result in avoidance of the agreement. What other problems may be, of course, that depends on the particular content of the agreement. But what I see is, for example, when a party, a contract between two businesses, where one of the businesses, a company, releases the debt. Let's say it says that, okay, you pay me not $1 million, but let it be 500,000. That would be enough. We are happy with that, so that's the content of the agreement, and we release you the other debt. So unfortunately, the tax authorities may be not happy about that. That they may find that this agreement, especially international transnational agreement, is just about concealing some illegal transaction, or for example, they may just tax that company for the whole money. So they receive only 500,000, but they are taxed for the 1 million. So unfortunately, as again, to my knowledge, there is a mistrust from some state authorities to transactions where a party does not require everything, but agrees to receive only part, which is normal for a settlement agreement. Exactly for this reason, many companies prefer to obtain an arbitral award or a court judgment, because if there is a judgment or an award, then they can easily refer to the judgment that that's our duty under the judgment or under the award, which is of course helpful, because if a duty under agreement is something that you agreed to, but a duty under award, that's already what you must do. That's a reason why some parties are reluctant to settle simply in an agreement.
But Dimitri, have you seen the grounds of refusal in the Singapore Convention? Do you see any practical problems there?
In the Singapore Convention, let me look at them again.
I'll put them up here. I'll put them up here. These are the.
So, since while I'm reviewing it, there are a number of grounds for the party opposing this enforceability, which it can rely on. But I guess it was just not possible to do without these grounds, because otherwise the international consensus would not become feasible.
Because I think, Dimitri, the issue is that when we look at the number E, when you look at E here, do you see any practical problems there? Are you giving too much of a leeway there?
One moment. So it is
this one here.
Yeah, there was a serious breach, yes, by the mediator. This ground.
Yeah.
That there was a serious breach by the mediator of standards applicable to the mediator or the mediation, without which breach that party would not have entered into the settlement agreement. Well, the problem is that there are no international standards applicable to any mediation, although there is some common understanding that mediator should be impartial, treat the parties on equal footing, and not act in favor of any of them, not consult them, and so on. So the problem may be to prove, or if still there is some situation where mediator did not comply with these basic fundamental standards, then it's hard for a party to prove that it was the case.
Yeah.
But I think that it's useful paragraph E, in the sense that indeed there should be an opportunity for a party to rely on such breach, though it may be not easy.
Well, I see issues here, because I see a lot of issues here, because it is an allegation you can make, and there is no, there are no witnesses or anything. The mediator is not going to say that I breached. The other party is not going to say that there was any breach. So it's you saying that there was a breach.
Yeah, sure, yes.
And what, like you just correctly said, what are those standards that you're talking about? Either you are saying that, of course, when you are talking about the domestic legislation under which it is done, in that there are provisions that could be one thing. All countries don't have I mean, the US also, for the mediations outside the court system, there is no some uniform law. So there was a uniform law which was taken out. All states did not take it. Other countries also, the similar situation might be happening. So how do you say the standards? I mean, really, that's something which is going to be not easy, although there must have been some reason to put it. Is it that institutions wanted their institutions, the standards they put on their certified accredited mediators, is that what they wanted to push there? Because look, mediation for me has to happen with people who don't have to be certified or accredited or anything. They can be, like, you can choose your, if you do not allowed to choose your own mediator, then there's a flaw in your legislation, because then the party autonomy goes. It's basically whatever, whoever they want to appoint, if you stop them from doing that, then definitely there's an issue. So if that is, if they can get anyone, then what are those standards which are applicable? So those, I think that's a discussion that needs to be had, how to take it, because I'm sure someone had some reason to put it there, but then it has to be further taken up through legislation maybe, or somewhere.
Indeed, the procedure is confidential, so normally, unless there are some records of communication with the mediator, and the mediator pushes pressure to one of the parties, so just tries to persuade it that the particular terms are very profitable to this party. To the benefit of another party. But of course, it's something extraordinary and also not easy to prove. Yeah, it's a problematic issue.
But Dimitri, what are the apprehensions for the convention? There is a convention on the, of course, enforceability of court judgments. So you're saying not too many countries have signed that. What is the issue there? Why are they not wanting to do it? Why are countries not wanting to sign that?
Very good question. Because now I can only guess that there is not yet enough trust to universal recognition of foreign judgments, that states may be ready to be open to enforcement of judgments of some other states, which, let's say, from their region, from their which they have special relations with. But this convention is universal, is about becoming open to judgment of any country of the world. So you sign it, then you ratify it, then you mean that please, any judgment from any part of the world, we are welcome to consider it and to enforce it in our country, of course, unless there are some grounds to refusal. Perhaps the legislators of many countries are not yet, or the governments not ready for such universal approach.
Do you think it's the government, or do you think it's the judiciary which is still being able to influence this, and they feel they're losing some control there? I don't know, because judiciary definitely plays a role there in controlling the government also to do certain things, because no one wants to be on the wrong side of the judiciary. That's what you see in a lot of countries. So do you think that's the reason? I mean, I don't know. You've studied this. I haven't studied these aspects, but I'm surprised that you said only 6 countries have signed it, is it?
Yeah, 6 countries. Yeah.
Because look, if you have to have the whole range, then
by the way, it's including the United States and Russia. Just interesting, and some others, Israel.
Yeah, because then it becomes a comprehensive thing. You have arbitration, you have mediation, and you have court judgments. So then these issues don't come up, because a lot of issues will come up in relation to the mediations also, because most countries today, mediation is through the court process. It's part of the court process. So definitely when that settlement agreement is entered into and the court passes a decree based on that, that will not be covered under the Singapore Convention. obviously is not covered under the New York Convention. And if this convention people haven't signed, then a large number of mediations and those settlement agreements will not be enforceable in other cross-border thing. So in a good, one good part about it is then you are going to tell people that you do not go through the court process. You do this, you have this settlement agreement outside the court, and you don't get a decree passed, and that by itself standalone should be enforceable in that country, and also because it's under the Singapore Convention, so it can be used outside. So something there will be a good thing in that sense, that at least mediation can go out of the courts, which is what I'm trying to do. I mean, I'm saying why do mediations have to stay there? So at least for cross border, we can tell them that do not stay in the court, do not get a court decree on this. Go outside, settle it outside, and just keep it there. Because look, in a country like ours, you've heard me maybe say about the law, and we have the best law on mediation, which is called conciliation. Now, that particular settlement agreement under that law is as good as a consent award. As good as. And a consent award is as good as a court decree. But it is neither a consent award, it is neither a court decree. So it will be covered under Singapore Convention. But are people going to challenge that also? I don't know. I mean, I don't know. Do you see any practical problems there?
To challenge what?
In our country, we have a law on conciliation. It's called conciliation, which I say is the best law on mediation that we have. Basically, the settlement agreement is as good as a consent award, consent arbitral award. And a consent arbitral award is as good as a court decree. But the settlement agreement is neither a consent award, so it can't go under the under New York Convention. It is not a court decree, so it won't be covered under, to say that it should not be covered under the Singapore Convention. But do you think people will take it up as a ground for challenging it and say you can't enforce it under the Singapore Convention because your law says it is as good as a consent award, which is as good as a court decree? Do you see any practical problems there?
Well, from the formal viewpoint, there is a potential argument, yes, for just very formal. That I see that the Singapore Convention is about out-of-court settlements. And
this is also, I'm saying this is also out of court. It is out of court.
But
it is out of
I
court.
think yet that argument would not be very persuasive against this enforceability, because indeed it's still an out-of-court settlement, yeah. So why not enforce it in this way? Anyway, it has the same value, as you say, the same effect, yes, as an arbitral award, as a court judgment, a court order, yeah.
Well, yeah, because what I'm trying to get at is that it means either you change the law, whenever you're tweaking the law because of the Singapore Convention, because definitely countries are ratifying it, so a lot of them will be passing the domestic legislation also. So there should be something there to show that no one can take advantage of the language used there and say, no, because it's as good as an arbitral award, they should go under the New York Convention. If you try and go under the New York Convention, say that this was a settlement agreement, there was no dispute, they can't go there. But I see really actually no problem, because first of all, of course, forget the New York Convention. It is not a court decree. It's only as good as a court decree for enforceability. That's all.
Yeah, for the purposes of domestic enforceability, probably.
Exactly.
Yes.
Exactly.
India.
Exactly. But it's not. It can't be. No one can say no. This is a court decree. In that sense, I mean, because a court decree will not be covered under the Singapore Convention. So that definitely is out. I mean, I'm just thinking, finally what happens is lawyers play with these words. That's what they do. And if you don't want the court to not enforce something, you'll come out with these arguments. So we have to maybe preempt those arguments and make sure that the language is used in a certain manner, because even like you gave an example of what happened in this case in the US situation. That one case will go around everywhere and people will start looking at it differently, which of course, I mean, I find that judgment perfectly all right. That's perfectly all right. There was no dispute, so what were you doing in the arbitration? So that's perfectly all right. So same thing, but in the Singapore Convention is just about starting off, and someone goes out and creates this kind of an issue that no, in their country this is as good as a court decree, and court decrees are not covered under the Singapore Convention, so you can't enforce it. So I'm just saying we have to be able to clearly look at the language required.
Yeah, unexpected problem.
Yeah, but why not preempt it? Because right now it's just being put into place. So why not preempt it? And even like I said, this particular thing that I showed you about the standards applicable to the mediator, this is actually something which domestic legislation maybe needs to clarify. Maybe that what are the standards applicable to that mediation. But here again, Dimitri, what we really have to look at is that mediations can happen anywhere, and the advantage of the Singapore Convention is there is no concept of the place where the mediation took place or the law under which it took place. All that has gone out, which is very good, because obviously the New York Convention, all those issues come up. Now the thing is, wherever that mediation takes place, as long as a mediation took place and a settlement agreement came out of it, you can get it enforced in any country which has ratified it. So it doesn't have to be in a country which has ratified it. You could have entered into a country which has not ratified it and get it enforced in a country which has ratified it. So in that kind of a scenario, these standards will become even a more gray area, because even if you say under a domestic legislation, the person said, I'm not going under any domestic legislation. We are just getting into this settlement agreement. This was a dispute we had and we settled it. I'm just thinking, I mean, we're just putting out thoughts just to look at what are the issues that have come up. So if there is no, I mean, you haven't said that this has to be done under so and so domestic legislation. So even providing for standards under a domestic legislation will be of no use. So then the standards become, I mean, I don't know how are there some now general standards that we have to start looking at? What are the standards applicable to the mediator, or if there are no specifics? I'm really one. This is something that I feel that this is one particular clause which will be really open to lots of interpretation and create issues.
Indeed, that may be a reason why some states are reluctant to ratify the convention, because there is too much uncertainty about who will mediate. Then no requirement, no standard. Indeed, as we discussed.
Yeah, because and the thing is that in that, after that, what it says is that, of course, serious breach of the standards, and without which breach that party would not have entered. Now that's the party saying that. It's a party saying that I would not have entered into it. It's as simple as that. We don't know whether you would have entered into it or not, but you say it. So it's just the word of the party. There is nothing else on the other side. Look, not disclosing the aspect of, I mean, in terms of impartiality or independence, I think this is something that has been discussed in relation to arbitration also. This thing does come up there. So then you'll find something there. But here, I don't know. This is a very, very gray area for me. Dimitri, you'll have to do, you are the academician, you will have to do some research on that. You have to come up with something there. One report that you have to come up on this particular clause only. Nothing. So only this aspect. What are the ramifications of it? How can it be misused? All those parts.
Yeah, thank you, Vikram, for drawing my attention also to this problem.
Yeah, because it is, I'm telling you, it is going to be something which will require lots of discussion. So we can have sometime later, we can have just a discussion on this. We'll have a discussion on Singapore Convention. And in that, we will focus, your Dimitri's focus will be only on this clause. That's it.
Okay.
So Dimitri, thank you very much. Is there anything else that you want to close the session on? Please, your last words, not your last words, your closing remarks.
No, thank you, Vikram, and all those who attend and who would like to hear. And I would happy to have your feedback of all people from all jurisdictions on the problem of enforceability of settlement agreements.
Yes, And we're doing it, Dimitri, we're doing it again on the 21st at 7 o'clock. So if anyone wants to be part of it, they can be part of the discussion with you. Yep. So that's on 21st, 7 o'clock. Perfect.
Okay.
So Dimitri, thank you very much. Always a pleasure speaking to you, and I mean, love your attitude towards things. So thank you, and we'll
Bye-bye.
see you then.